Good day, everyone. We will now discuss the crimes against the fundamental laws of the state. So it starts from Article 124 and ends at Article 133. Okay, so what are the crimes against the fundamental laws of the state? So the first is stated in Chapter 1, which includes arbitrary detention, violation of dwelling, prohibition, interruption, and dissolution of peaceful meetings, and crimes against religious worship. So, what are the crimes against the fundamental laws of the state? So, they are arbitrary detention, that's found in your Article 124, the delay in the delivery of detained persons to the proper judicial authorities, found in your Article 125. And then we have the delaying release in Article 126, expulsion in Article 127, violation of domicile, Article 128, search warrants maliciously obtained and abuse in the service of those legally obtained in Article 129, searching domicile without witnesses, Article 130, and prohibition, interruption, and dissolution of peaceful meetings, Article 131, and the interruption of religious worship. Okay, so let's now start with section 1, arbitrary detention and expulsion. So these are the classes of arbitrary detention. We have arbitrary detention by detaining a person without legal ground. We have delaying the delivery of detained persons in the proper judicial authorities and delaying release. Take note of the terms ha kay basig malibog mo ani inig MCQ ninyo, so you have to really see to it nga dili mo ma-confuse, na hindi kayo ma-confuse of the terms. Okay, so the penalties for the three classes of arbitrary detention are the same as provided in Article 124, Article 125, and 26. Article 124. Ang Articles 125 and 126 do not provide penalties for their violation. So they make reference to the penalties provided in Article 125, 124 rather. Now let's start Article 124. Arbitrary detention. Take note that any public officer or employee who, without legal grounds, detains a person shall suffer the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period if detention has not exceeded 3 days. Okay, remember of the number of days. Okay, so exceeded 3 days. Penalty of prisión correccional in its medium and maximum period if the detention has continued more than 3 but not more than 15 days. And then the penalty of presión mayor if the detention has continued for more than 15 days, but not more than 6 months. And if reclusión temporal, if the detention shall have exceeded 6 months. So the crime or the commission of a crime or violent insanity or any other ailment requiring the compulsory confinement of the patient in a hospital shall be considered legal grounds for the detention of any person. So if a person is detained because of the commission of a crime or because of violent insanity or any other ailments that would require the said person compulsory confinement, kana siya or that will be considered as a legal ground and a person cannot be held liable for arbitrary detention. Now, what are the elements of arbitrary detention under Article 124? These are the following: that the offender, uh, if a public officer or employee, this is isa, and that he detains a person and that the detention is without legal grounds. So remember of the phrase, the detention is without legal grounds. So the offender in arbitrary detention, remember this, is a public officer or employee. Okay, so the public officers liable for arbitrary detention must be vested with the authority to detain or order the detention of persons accused of a crime. But when they detain a person, they have no legal grounds, therefore. Okay, so remember that one can only be prosecuted for arbitrary detention if he or she is a public officer or employee, and that ang detention or the order of the detention of the accused is without any legal grounds. Okay, so these public officers are policemen and other agents of the law, mga judges or mayors, A barangay captain and a barangay council or municipal councilor is also or are also considered public officers. So note that if the detention is perpetrated by other public officers, the crime committed may be illegal detention because they are acting in their private capacity. Okay? If the offender is a private individual, the act of detaining another is illegal detention under Article 267 or Article 268. But private individuals who conspired with public officers in detaining certain policemen are guilty of arbitrary detention. Okay, if they are conspiring with public officers, they cannot say, "Oh, I could not be prosecuted for arbitrary detention because I'm a private individual." No, because if they conspire with public officers, they will also be considered to have committed arbitrary detention. Okay. So when is there a detention? When can you say that there is detention? This is when there is an actual confinement of a person in an enclosure or any manner detaining and depriving him of his liberty. So a person is detained when he is placed in confinement or there is a restraint on his person. Okay. Also note that there is restraint resulting from fear. Okay. This one case no of Astorga versus People, where the accused mayor refused to allow a DENR team to go home despite their pleas, and the refusal was quickly followed by the call for an arrival of almost a dozen reinforcements, all armed with military issued rifles. Who proceeded to encircle the team, weapons pointed at the complainants and the witnesses, and the team was instead brought to a house where, after dinner, some of the members were allowed to go down from the house but not to leave the barangay, and the rest just sat there in the house until 2 a.m. When they were finally allowed to leave, it was held that the resulting or the restraint resulting from fear is evident. So it was not just the presence of the armed men, but also the evident effect that these gunmen had on the actions of the team, which proves that fear was indeed instilled in the minds of the team members to the extent that they felt compelled to stay in the barangay. So the intent to prevent the departure of the complainants and witnesses against their will is clear. And in this case, it was considered as arbitrary detention. Now, when we talk about without legal grounds, what is meant by the phrase without legal grounds? Simple lang. The detention of a person is without legal grounds when he has not committed any crime, or at least there's no reasonable ground for suspicion that he has committed a crime, or when he is not suffering from violent insanity or any other ailment requiring compulsory confinement in a hospital. So in this case, a barrio lieutenant seeing his servant quarreling with his daughter, seized the servant, and an hour later sent him to the Justice of Peace. The servant was kept in detention from 9 p.m. to 9 a.m. the next day when he was released by the Justice of Peace. It was held by the Supreme Court that the barrio lieutenant was guilty of arbitrary detention because he detained the offended party without any reason, therefore, such as the commission of the crime and without having the authority to do so. Okay. Note that merely quarreling is not a crime. So a Manila detective sergeant arrested Aquilino Tarok because of the suspicion that he might be implicated in the plot to assassinate the president and that he was related to Luis Tarok, a hook supremo. It was held by the Supreme Court that a mere suspicion of his connection with any murderous plot is no ground recognized by law for restraining the freedom of any individual. Lawlessness from above can only lead to chaos and anarchy, and it's not considered as um, um, uh, legal ground for you to detain a person. Okay. Also, in overtaking another vehicle, complainant driver was not committing or had not actually committed a crime in the presence of respondent judge. Such being the case, the warrantless arrest and subsequent detention of the complainant were considered illegal in the case of Callao versus Del Mundo. Now, when is there legal grounds for detention of any person? So, the following are legal grounds for the detention of any person. If there's a commission of the crime, and we've said earlier, if there's violent insanity or any other ailment requiring the compulsory confinement of the patient in a hospital. Okay. Um, Note that kanang mga arrests without warrant, they're basically considered as a usual case of arbitrary detention. Okay. So remember that a peace officer, when you become police officers, you must have a warrant of arrest properly issued by the court in order to justify an arrest. And if there's no such warrant of arrest, the arrest of a person by a public officer may constitute arbitrary detention. However, you also have to note that there are also circumstances that may warrant a lawful arrest. Kanang mga infragrante delicto, mga caught in the act, mga hot pursuit. These matters will be taken up in your criminal procedure. Okay? Now look at this case. A constabulary officer was engaged to marry a girl, but later the engagement was broken. Thereafter, while the officer was passing in front of the girl's house, he was assaulted by the girl's two brothers after the girl had approached him in a friendly manner, which she never did before. So he suspected that the girl had conspired with his assailants, and so he ordered her arrest and detention. The officer filed a complaint against the girl and her brothers. For her arrest and detention, the officer was charged with arbitrary detention. So in this case, the Supreme Court said, Caning People versus Ancheta, that the constabulary officer was not guilty of arbitrary detention. Note that the constabulary officer, in ordering the arrest and detention of the girl, had probable cause to believe that the girl participated in the assault as one of the conspirators. Okay? In arbitrary detention, the legality of the detention does not depend upon the juridical and much less the judicial fact of the crime, which at the time of the commission is not and cannot definitely be determined for lack of necessary data and of jurisdiction, but upon the nature of the deed. It is sufficient, according to the Supreme Court, that the agent or person in authority making the arrest has reasonably sufficient grounds to believe the existence of an act having the characteristics of a crime, and that the same grounds exist for him to believe that the person sought to be detained participated therein. So, in this case, naingon ng Supreme Court that the obligation to make an arrest by reason of crime does not presuppose as a necessary requisite for the fulfillment thereof, the indubitable existence of a crime. And under section 5 of your rule 113, which you will learn later in your criminal procedure, the actual commission of a crime by the person detained is not necessary to justify his detention. The legality of the detention of a person does not depend upon the actual commission of a crime by him, but upon the nature of his deed when its characterization as a crime may reasonably be inferred by the officer to whom the law at the moment leaves the decision for the urgent purpose of suspending the liberty of that person. Okay? Also note that there's no reasonable ground if the officer only wants to know the commission of the crime. Okay. In the case of U.S. versus Ho Chow, in a case where the accused was arrested and prosecuted for illegal possession of opium, the witness testified that the only reason why he ordered the arrest of the accused was that he was acting suspiciously. He did not say in what way the accused was acting suspiciously or what was the particular act or circumstance which aroused his suspicion. He caused the arrest because, as he said, I wanted to see if he had committed a crime. So it was held by the Supreme Court that it was not a legal reason for him to make an arrest. Okay? Hindi pwede na you would see na, I just want to know if he committed a crime or what. No, you cannot do that. Okay? The Supreme Court said that there's no reasonable ground if the officer only wants to know the commission of the crime. Okay? So let's now proceed to Article 125. In Article 125, this article is usually used during custodial investigation and during what they call this, no, not custodial inquest. Okay, during inquest. If the accused during inquest would want to undergo preliminary investigation, he would be asked by the prosecutor to waive this particular article. So what's in Article 125? This is the so-called delay in the delivery of detained persons to the proper judicial authorities. So when is there a delay in the delivery of detained persons? So the penalties provided in the next preceding article shall be imposed upon the public officer, meaning yung penalty in Article 124, okay? Shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties or its equivalent, 18 hours for crimes or offenses punishable by correctional penalties or their equivalent, 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. So in every case, the person detained shall be informed of the cause of his detention and shall be allowed upon his request to communicate and confer at any time with his attorney or counsel. That's provided for in your Article 125. So what are the elements, no? Again, the offender here is a public officer or employee, and that he has detained a person that he fails to deliver such person to the proper judicial authorities within 12 hours, 18 hours, 36 hours, depending on the gravity of the crime. Okay? So remember the days, remember the number of hours, and remember the types of penalties, okay? The classification of penalties. So remember that. Now, if the offender is a private person, the crime is illegal detention. Okay, a private individual who makes a lawful arrest must also comply with the requirements prescribed in Article 125. If he fails to do so, he shall be guilty of illegal detention, not arbitrary detention, because as what we have said earlier, ang arbitrary detention will only be considered a crime for those who are considered public officers or employees. Okay. However, the periods of time in Article 125 will be applied to the arrest made by a private person, the same number of hours, which you will be considering in determining if there is already an illegal detention. Okay. Now, let's look at this case of Lino versus Puguso. This is a very old case decided by the Supreme Court. So what are the facts of this case? So si Pascual Montañal was arrested without a warrant by the police officers of Manila on November 8, 1946 for inciting to sedition, and Pacifico Duco on November 7, 1946 for resisting arrest and disobedience to police orders. On November 11, when this petition for habeas corpus was filed, these two petitioners were still under arrest, and they were thus held in confinement for 3 and 4 days, respectively, without warrants and without charges formally filed in court. And then the papers of their cases were not transmitted to the city fiscal's office until late in the afternoon of November 11. So upon investigation by the office, no sufficient evidence was found to warrant the prosecution of Pascual Montañal for citing to sedition and of Pacifico Diodoco for resisting arrest, but both remained under custody because of informations filed with the municipal court charging Montañal with unjust vexation and Diodoco with disobedience to an agent of a person in authority. And so far, no warrants of arrest or orders of commitment are shown to have been issued by the municipal court pursuant to the informations thus filed. So, under these facts, the detention of Pacifico, according to the Supreme Court, the detention of Pacifico Diodoco and Pascual Montañal is illegal, even assuming that they were legally arrested without a warrant on November 7 and 8, 1946, respectively. Their continued detention became illegal upon the expiration of 6 hours without their having been delivered to the corresponding judicial authorities. Okay? So remember that Article 125 does not apply when the arrest is by virtue of a warrant of arrest. Okay? Article 125 will only apply if it was made without a warrant of arrest. Okay? But the arrest must be lawful. As I've said earlier, there are instances wherein you can actually make an arrest even without a warrant provided for in your criminal procedure. Okay? So, mga inflagrante delicto, mga pursuit, mga fugitive from justice. Okay? So, if the arrest is made with a warrant of arrest, the person arrested can be detained indefinitely until his case is decided by the court or he posts a bail for his temporary release. Okay? The reason for this is that there's already a complaint or information filed against him with the court which issued the order or the warrant of arrest, and it is not necessary to deliver the person thus arrested to the court anymore. Okay? Now, let's look at this case of Agbay versus Deputy Ombudsman for the military. So, what happened in this case is that on September 7, 1997, a certain or the petitioner and a certain Sherwin Hugalbot were arrested and detained at the Liluan Police Station, Cebu, for alleged violation of RA 7610, the Special Protection of Children Against Abuse, etc., etc., before them in the MCTC Liluan. So on September 10, Counsel for Petitioner wrote the Chief of Police of Liluan demanding the immediate release of the petitioner, considering that the Chief of Police had failed to deliver the petitioner to the proper judicial authority within 36 hours from September 7. Now, private respondents did not act on this letter and continued to detain the petitioner. On September 27, a complaint for delay in the delivery of detained persons was filed against the respondents who are police officers stationed at Liluan Police Station. So it was held by the Supreme Court that Article 125 of the RPC is intended to prevent any abuse resulting from confinement or from confining a person without informing him of his offense and without permitting him to go on bail. Upon the filing of the complaint with the municipal trial court, the intent behind Article 125 is satisfied, considering that by such act, the detained person is informed of the crime imputed against him, and upon his application with the court, he may be released on bail. Okay? So again, what's the reason behind the provision of Article 125? According to the case of Laurel versus Mesa, this is intended to prevent any abuse resulting from confining a person without informing him of his offense and without permitting him to go on bail. Okay? So how do we distinguish Article 125 from Article 124? In Article 124, the detention is illegal from the very beginning. In arbitrary detention, ang detention here is legal in the beginning, but it becomes illegal from the start of the expiration of the period provided for in Article 125 without the prisoner detained having been delivered to the proper judicial authority. Okay, so that's basically the difference. In Article 124, from the very beginning, the detention is illegal. Okay? In Article 125, from the very beginning, legal pa ang detention. However, after the expiration of the period provided for in Article 125, it becomes illegal because of the failure of the police officers to deliver the said person detained to the proper judicial authorities. Okay? Just take note of those distinctions. Kasi baka malito kayo during your exams and you will fail to distinguish the difference between the two. Okay? Article 126 is the delaying release. Okay, so the penalties still provided in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detainer or detention prisoner or unduly delays the service of the notice of such order to said prisoner or the proceedings upon any petition for the liberation of such person. So what are the acts rather punishable under Article 126? These are delaying the performance of a judicial or executive order for the release of a person. That's the first. Second, unduly delaying the service of the notice of such order to said prisoner. Third is by unduly delaying the proceedings upon any petition for the liberation of such person. So the elements of delaying release are the following: that the offender is a public officer or employee, that there is a judicial or executive order for the release of a prisoner or detention prisoner, or that there is a proceeding upon a petition for the liberation of such person, and that the offender without good reason delays the service of the notice of such order to the prisoner or the performance of such judicial or executive order for the release of the prisoner or the proceedings upon the petition for the release of such person. Now, what are the examples of delaying release? So, for failure to prosecute because the witness of the prosecution did not appear, the case was dismissed, and the justice of peace gave an order to release the accused. In this case, the jailer refused to release the accused. So, here, the jailer was considered to have violated Article 126, delaying release. So basically, the public officers that are who are more likely to commit the offense under Article 126 are wardens and peace officers, temporarily in charge of the custody of prisoners or detained person. Okay. Now let's go to expulsion. When we talk about expulsion, the penalty of prisión correccional shall be imposed upon any public officer or employee who, not being thereto authorized by law, shall expel any person from the Philippine Islands or shall compel such person to change his residence. So basically, there are two acts that are punishable under Article 127. First is the expelling a person from the Philippines, and the other one is by compelling a person to change his residence. So again, the elements, the offender here is a public officer employee, and that he expels the person from the Philippines or compels that person to change his residence, and that the offender is not authorized to do so by law. Okay. So what is meant by not being authorized to do so by law? So in the case of Villavicencio versus Lukban, only the court, the final judgment, can order a person to change his residence. This is illustrated in ejectment proceedings, expulsion proceedings, and in penalty of destierro. So therefore, the mayor and the chief of police of Manila cannot force the prostitutes residing in that city to go to and live in Davao against their will, there being no law that authorizes them to do so. These women, despite their being in a sense lepers of society, are nevertheless not chattels, but Philippine citizens protected by the same constitutional guarantees as our other citizens. Because in this case, Manggod, the prostitutes were ordered by the mayor and the chief of police of Manila to transfer from Manila to Davao. Okay, them being prostitutes, and according to the Supreme Court, you cannot do that because these persons are citizens of the Philippines, and they have the right to live where they want to live. They have the right to the same constitutional guarantees as our other citizens. Okay, so that's expulsion. Let's go to Article 128, 129, and 130, the crimes known as the violation of a domicile. Okay, what's provided for in Article 128? Article 128 is the violation of domicile. Okay, the penalty of prisión correccional and its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or having surreptitiously entered said dwelling, and being required to leave the premises, shall refuse to do so. If the offense be committed in the nighttime, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prisión correccional in its medium and maximum period. Okay. So there are three acts that are punishable under Article 128. No. First is entering into a dwelling against the will of the owner. Ikaduha, searching papers or other effects found therein without the previous consent of such owner. Third is by refusing to leave the premises after having surreptitiously entered the said dwelling and after having required to leave the same. Okay, so What are the elements common to these particular acts? The offender is a public officer again or employee, and that he is not authorized by judicial order to enter the dwelling and or to make a search therein for papers or other effects. Okay. So remember that the offender must be a public officer. Okay. And that public officer enters the dwelling against the will of the owner. If the offender is a private individual, the crime is not trespass to dwelling, but trespass not the semi violation of domicile, but trespass to dwelling. Okay. What is meant by the phrase not being authorized by judicial order? So, according to the Supreme Court, a public officer employee is authorized by judicial order when he is armed with a search warrant duly issued by the court. Hence, he is not authorized by judicial order when the police officer or the public officer has no search warrant. Okay. And here, remember that the officer, in order to make an arrest, either by virtue of a warrant or without a warrant of arrest, as provided in Section 5, may break into any building or enclosure where the person to be arrested is or is reasonably believed to be if he is refused admittance thereto after announcing his authority and purpose. So the reason for this provision is that while it may be true in general that a man's house is his castle, it is equally true that he may not use that castle as a citadel for aggression against his neighbor, nor can he, within his walls, create such disorder as to affect their peace. Okay, that's in the case of US versus Vallejo. Also note that in the case of US versus De Los Reyes, the Supreme Court said that the mere fact that a visitor of the house of another is suspected of having an unlawful possession of opium is no excuse for entry into the house by a peace officer for the purpose of search against the will of its owner and without search warrant. Okay. Now, suppose that the opium found after search without the previous owner of the house, without the previous consent of the owner of the house, belonged to the said owner, and that the peace officer had no search warrant. Is the peace officer liable for violation of domicile? Yes, the police officer may still be held liable for violation of domicile because no amount of incriminating evidence, whatever its source, will supply the place of a search warrant. Okay. Now, Article 129 penalizes search warrants maliciously obtained and abuse in the service of those legally obtained. Okay, so there's a penalty here provided, and remember that the acts punishable in this particular article is when you procure a search warrant without just cause, and if you exceed your authority and use unnecessary severity in executing a search warrant legally procured. Okay. So on something a search warrant, in your criminal procedure, you will learn that a search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a police officer commanding him to search for personal property described in the said warrant and bring it before the court. You will learn that when you go to criminal procedure, no, that's provided for in Rule 126 of your criminal procedure. So what are the things man to be seized in a warrant and a search warrant? Um, the following may be searched and seized, no, subject of the offense, stolen or embezzled, and other proceeds of the fruits of the offense, or the used or intended to be used as a means of committing an offense. Now, when can we say that a search warrant is said to have been procured without just cause? A search warrant is said to have been procured without just cause when it appears on the face of the affidavits filed in support of the application, therefore, or through other evidence that the applicant had every reason to believe that the search warrant sought for was unjustified. An example here is that a peace officer wanted to verify a report that some corpse was unlawfully buried in a monastery. So instead of stating to that effect, he alleged in that affidavit that an opium was hidden in the premises. So if no opium was found, the officer here is guilty of search warrant maliciously procured. Okay, because that peace officer should have stated in the affidavit that what he really intended to search is the is those corpses or some corpses that were buried in the monastery. Okay. Now, if you search also a domicile without a witness, you can also be prosecuted. Okay. Again, this can only be committed by a public officer or employee. Okay. Um, Note that the word search means to go over or look through the for the purpose of finding something to examine. Note also that the thing searched by the offender is the domicile, the papers, and other belongings of any person. The public officers may examine the papers for the purpose of finding in those papers something against their honor or his other belongings for the same purpose. But as the crime defined in Article 130 is one of the forms of violation of domicile, the papers or other belongings must be in the dwelling of their owner at the time the search is made. Okay? So Article 130 does not apply to searches of vehicles or other means of transportation because the searches here are not made in the dwelling. Okay? Now, kaning prohibition, interruption, and dissolution of peaceful meetings, no Article 131, Article 132, and Article 133 are basically matters of reading. I hope that you find time to read those. Wala pa kayo ko kita o questions in the board exams, no? Appearing or asking for Articles 131 to 133. But for purposes of having a working knowledge on these articles, kindly read those, okay? Thank you very much. See you guys next time. Bye.